of the 5 suspects implicated in the 2014 murder of former Orlando Pirates goalkeeper Senzo Meyiwa have chosen not to have legal representation. They've also refused to stand in the dock in court. For more on what this means for their cases, we're joined by the High Court Advocate Manny Witz and Criminal Defense Attorney Tyrone Maseko. Good evening to both of you, gentlemen. It's a pleasure to have you on. Manny, perhaps let me begin with you. Your general impressions of how today unfolded in court and what is going on here with this case.
Yeah, evening to you and evening to the viewers, and hope everybody's staying safe and looking after. It's very, very simple. The arrests were made. They were issued in terms of warrants of arrest, bench warrants that were obtained in order to arrest the suspects. Obviously, after long investigation, forensics and everything has been done. The approach adopted by the accused in this particular matter will obviously be seriously looked at, and in all these type of matters where you face, as they are charged, a minimum sentence, which in terms of the legislation, which imposes minimum sentences in the event of a conviction, the courts will ensure that you do have legal representation. And there's a warning to all future suspects and all future accused. The courts have to, any presiding magistrate, they have to inform you of your legal rights in terms of the Constitution and your rights to a defense of your own choice. If you cannot afford it, they will provide you with legal aid. All the courts have got legal aid officers that are attached to that particular court, and the courts will actually insist that you can't do the case on your own, especially with the consequences of a minimum sentence, and they will try and ensure that they all get proper legal representation, whether it's through the legal aid. If they cannot afford it, there's a means test, and if not, they can choose private attorneys or private advocates. So that's what will happen in this particular matter. And once the indictment and the charge has been served upon them, what they can then do is, within a certain period, after appearing in court, they can bring applications to be released on bail, pending the eventual trial. And the state will then elect whether to oppose or whether or not to release them on bail. And in terms of the fact that it is what is called a Schedule 6 offence, which is one of the more serious offences, which is murder in this particular case, the accused have to show special and exceptional circumstances in order to be released on bail. So it's not just a done thing that you'll be released on bail. You have to bring a formal application, either via evidence, and whatever you say in a bail application can be used against you in the pending trial that's to come. So that's really what happened in court today. So the first thing that the presiding officer will do will be to ensure that they've got proper legal defence in terms of their constitutional court rights, in terms of Section 35 of the Constitution Act 108 of 1996. Every citizen and every person in the Republic of South Africa is entitled to a legal defence. So I've got no doubt that the court, when dealing with the matter, will first ensure that all their rights are explained, and secondly, that they do get some form of legal defence, because it's a complicated case. It's not an easy case. It's been a long time in investigation, and you would need proper legal representation in order to defend such a case.
Tyrone, when we look at what the suspects were saying in court today, they of course have said they've been arrested, some since June, and another suspect saying in August, and the rest seem to have already been serving sentences for other crimes. Does it matter that that information is not the same as the information that the Minister Bekele gave us, or is it because of our simplistic understanding of these things? If the Minister says people were arrested yesterday, we, of course, as the public, think that's when the police went to round them up and put them behind bars.
Yeah, look, it's a very strange one, Kathy, in the sense that there seems to be a conflation of matters. If you've got accused who are already in custody, so either pending trial, which means that this would be related to other matters, which have got presumably nothing to do with this. So those matters would have to run their course, because they're totally unrelated to this matter. I mean, the only thing that becomes relevant is the question of the court diary, because obviously they'd have to appear or run trial, face trial in those separate matters, and what you don't want is to have dates overlapping. So I think for our purposes, we should try and separate matters. This trial will have nothing to do with whatever charges they're facing in other matters. And insofar as they've been convicted of other crimes, they'll have to serve those sentences. So for all intents and purposes, we have to put that aside and look at this matter on its merits and deal with the issues that they face in this particular trial. What's interesting to me is that, and where we have to be careful is because of the public attention on this matter, we don't want it to affect the administration of justice. You know, when you have politicians and high office bearers in the SAPS coming and making public pronouncements as they did yesterday, I suppose one can understand why they do it from their perspective. But it's important that for investigators and the NPA that they have to focus on what they need to do. They know what the processes are. And you run into trouble because now you have dual processes where things get said in court and they then have to answer as to, well, public officials have said X, Y, Z, and that becomes a distraction. So I think it would be important that, you know, politicians and the like step aside and give this process a fair chance to run its course, because accused have rights as well. You know, you watch today, they're very frustrated, they're unhappy about this. They have to be given a fair chance to present their case without the public pressure that we're seeing. I think that's it's important to bear in mind.
Advocate Wits, Tyrone is talking about the rights of the accused and how those need to be given a platform within the court. At the same time, of course, the NPA has said, well, they weren't expecting the accused to come to court and admit to any of the charges that have been leveled against them. And I think the public generally seems to be leaning on the side of the accused when they say that they haven't committed the crime.
Oh, look, Tyrone is 100% correct what he was telling you about the rights of an accused. But more importantly, what your viewers need to know, there's no trial at this stage. This is still the preliminary stages. This is the initial arrests, and the allegations and the indictment relate to a murder charge, possession of unlicensed ammunition, and an attempted murder charge arising out of the incident. So you first have to get your initial appearances in court, then you get your applications for bail, then you get what is called a copy of the indictment and the charges and the list of witnesses, and then you get, as an accused, in terms of your rights, the disclosure. So in other words, they will give you a copy of the criminal docket with all the statements, if there's a photograph album, if there's any videos, if there's any keys, any electronic keys to the plan of where the incident occurred, everything that the state intend using in order to try and prove the case against the accused is now, in terms of the Constitution, already the 1994, the interim Constitution, and then in 1996, the final Constitution. Every accused in terms of Section 35 is entitled to all of this to ensure not only do they get a fair trial, but also to ensure that they get a speedy trial so that there's no long delays. It has taken time, as the public know. There were a lot of investigations and other intricacies involved that will obviously come out, ballistics, etc., which will come out obviously in the evidence in the trial. But you have to look after the accused's rights. And the presiding officer at this stage that's dealing with it, which is normally in the lower court, they appear in the lower courts, I've got no doubt that this particular case, because of the fact that it's a murder, they will transfer it to the High Court. And when it gets transferred to the High Court, which is your Supreme Court of your local division, that is when the matter will start unfolding. But till then, there's a lot of interlocutories and a lot of applications that will occur, and the accused, all their rights will be protected. From bail applications to disclosure of all the statements, the evidence against each individual accused, whether they're alleging a common purpose, whether they were all in it together, and how they link the accused. All that has to be dealt with, and only when it goes to trial, when all these procedures have been done, then the presiding judge, whether it's a he or she, and they normally ask you in matters of this nature whether you want assessors. So they appoint, normally in murder cases, they give the accused and the defense a chance. They ask you whether you would like assessors to assist the presiding judge. And they always appoint, they've got a pool of assessors. You have to have 2 assessors next to the judge. And these assessors that your viewers need to know, they play a very, very important role. They normally try and get people who have got some legal background or legal training or experience in courts. And what these assessors can do, they can, at the end of the day, after hearing all the evidence, they don't give the judgment, but they can give their indication to the presiding judge. And if it's 2 against the 1 judge, often in certain cases, the assessors, if they decide there should be an acquittal or a conviction, and it differs from that of the judge, if there are two assessors, and I think your viewers need to know this, the assessors play an important role. The only time they don't play a role is after there's been a conviction. If there's been a conviction and somebody has been found guilty, or various of the accused are found guilty, they play no role at all in the type of sentences that will be imposed. But this case has still got a way to go, but I think the way that it's been investigated and the way that it's now been brought before the courts, it looks like it should be ready quite soon after all these applications have been done to transfer it to the High Court. The problem that the viewers need to know, unfortunately, with the world pandemic and with this COVID-19, I think the court roles have been very, very adversely affected, especially in matters of this nature. And I'm not sure what the court roles are looking like. The role planner at the Director of Public Prosecutions will have to see, because the courts divide up into 4 different terms, into which term and when the advocates for the defense are available, when they can actually set down a trial date. But the only benefit of that, of course, for the accused, and in particular for the defense and also for the state, is normally when it goes to the High Court, they have what's called a continuous role. So you get your one judge, you get either 1 or 2 prosecutors, you've got your defense, and the matter will continue the next day. It's not like the magistrate's court, where Tyron has correctly put it out to the viewers, where there's a lot of other matters that they have to deal with. So once it's transferred to the High Court, you have what's called a continuous role. So it will go from Monday to Friday, excluding any public holidays and obviously excluding weekends. So normally these matters tend to run, and you get your witnesses, you get your evidence, and the judge, he or she, can concentrate, and if there are assessors, on the one trial only. And you saw it in, for example, the matter of the state versus Oscar Pistorius, where the matter ran, and only unless somebody's unavailable or something untoward occurs, they normally go quite quickly, because you don't get distracted by other matters. So the judge, he or she, can deal with the matter at hand. So hopefully in this particular matter, and normally in these matters where it's a murder involved, not because of the unfortunate tragedy and the victim, in this particular matter and the so-called prominence and what our ministers and the Minister of Police are saying, but in matters of this nature, they always transfer them to the High Court in order to provide for a continuous role until the matter can proceed, so everybody will get a fair trial and will be a speedy trial as well.
Tyrone, I just want to draw your insights then on what we also saw happen today. In terms of the leaking of this information, we're now told, and this is from the investigating officer, on what the state still needs to do before this case is heard on the 27th of November. Many of those things that are listed there, including cell phone data on where, who was at a particular time, evidence around DNA. What happens if that information is not ready in time?
See, Kathy, this is exactly the problem that you have when you have parallel processes, where you've got police know exactly how to investigate matters and what it is that they need to do, and they have to work with the NPA, and only with the NPA. There shouldn't be added influence and pressure on them. Why? Let's give an example. These people have now appeared in court, so they've now been charged and they've appeared in court. So the court processes are now in action. One of the questions that we have to ask is, was it a good time for them to be charged, given that now there are all these allegations that the instigators probably, still out there, has not been charged, and all sorts of questions, which suggests to me that it probably would have been good to actually wait and do a proper investigation and conclude the investigations before they actually charge these parties, because now you've got an incomplete number of accused in the dock. You have to now answer the question, well, should we be charging other people, and should they stand trial with these people who are already in the dock, the 5 of them? Why rush to charge them if some of them are already in custody? If they're already locked up, they're not going to flee, they're not going anywhere. You've got absolutely nothing to gain by charging them right now. Finish your investigations first, because what you're going to see start to happen is the NPA is going to start to ask for postponements after postponements, because they've concluded the investigations. But all of this happens at a time at which the accused are already appearing in court. What is the benefit of that? Why rush to charge them if you're not ready to go to trial? Because as far as I'm concerned, parties should only be charged and be brought to court when the state is ready to say, right, the very next process here is to disclose the docket so that the other side can have a look at it, and then we can set this matter down to trial. So we can transfer it to the High Court for trial. Not to have, as we've seen in the Zuma matter in Durban or Pietermaritzburg, where you've got these continuous postponements because of investigations and other parallel processes that are not completed. All of that stuff is just a waste of the court's time. So that is problematic. And I think it's important that they actually go back to the drawing board and ensure that the investigations are complete and disregard all these noises that are happening outside and focus only on the matter, lest they make mistakes which are going to be very costly in the long run.
Advocate Manny Wits, and who is an advocate of the High Court, and attorney Tyrone Maseko, who does criminal defense work. Thank you so much for your time and that analysis on News at Prime tonight.